Before we get into today's episode, I just want to give a quick shout out to my new sponsor, Inflow Finance. I'm genuinely happy to support them because I've worked with them myself. Inflow is a specialist bridging and development finance lender, and what really sets them apart is that they are 100% funded privately with no credit committees, fewer restrictions, and a much faster decision-making process. In my experience, when Inflow issue terms, they rarely change, and they're genuinely always ready to lend, which makes a huge difference when you're trying to keep a deal moving, when funding a development project, or when your current loan is due to expire or has already come to term. If you are a developer, investor, or broker looking for refurbishment, development, or bridging finance, then Inflow is the right lender for you because they truly understand property. Do reach out to them via their website, inflowfinance.com, or scan the QR code below. Hi, I'm Mani Chopra, and welcome to another episode of Passion for Property with me. And today's guest is a very friendly litigation lawyer. I know it sounds weird, but he is. He's a senior litigation partner at Ron Fletcher Baker, actually. He loves Brazilian Jiu-Jitsu and he's now taken on paddle. You can't get more trendy than that. Please welcome David Burns.
Thank you very much for having me, Manny.
Thanks for making it come all this way. So really appreciate you coming along today. So I wanted to kickstart with just asking you a little bit about what was life like, a quick snapshot of life before property law.
Right. Well, my background is I'm Irish, obviously, so I grew up in Northern Ireland. I don't know how much people will understand of my accent or the You will? Do you think so? Okay, that's good. So I grew up in Northern Ireland, but moved over to England after university and started practicing criminal law. So I did that for from 2006 probably through to around, I think, 2012, 13.
So was that murders and
rapes and burglaries and everything you can think of. I was in a law firm in Tottenham, Wilson's, which was a good law firm, and it gave me a really good grounding because I was dealing with jury trials in the Crown Court and doing my own advocacy.
So were you on the prosecution side of it or defence?
Defence. My wife is on the prosecution side and I'm on the defence. I met my wife in court when I was defending
on the same case.
Well, at that point, yeah, it was a case, and I met my wife during that case.
Trial.
It was a guy who'd went into a shop with a fire extinguisher and just sprayed an extinguisher all over the shop. So it was criminal damage was the allegation.
Right.
But yeah, that was...
Did you enjoy that?
I did enjoy it. It was really good and fun, and we had a really good team. The difficulty was that the money in it wasn't that great. No, because it's generally funded by legal aid.
Right.
And so, the political will for paying lawyers to defend criminals is not high up. Of
course, why would it be as well, right?
Exactly,
and rightly so, if you don't mind me saying.
Exactly, is that ever going to change? So at some point I took a step back and thought, I probably need to change path.
I need some more money.
And also what happens is these, a lot of the people who are accused of crimes, they're arrested at 2-3 in the morning. So they'll call up, you get an officer, David, we've got this person, Jason's in the cell. He wants you to come down to the police station. So I thought,
my God. It was far from a 9 to 5 that you were looking for as a lawyer.
Yeah, exactly. So I thought if I'm going to have a family and build a career. And the thing is as well, I was always interested in property. So then I thought, what should I move? I need to move into something else. I thought of doing conveyancing. The managing partner at the time said, no, you'd be better suited to disputes and litigation. So I jumped.
I'm not going to lie, but I think you're the friendliest litigation lawyer I have ever met.
Really? That's a good...
Absolutely. And I think it's definitely a compliment.
Is that a compliment?
Well, it's great because, that's the first thing, right? You already are in a dispute and, you're obviously maybe, money down or whatever down the drain. And you need a friendly guy, right, to take you on and say, look, we can help you out.
You do. And also you need, not every case needs to run all the way to a trial.
Yeah.
Because for a lot of clients, it can cost a lot of money to get all the way to a trial. And you don't know ultimately whether a judge is going to find in your favour or not. So if there's a way of reaching out to the other side, doing a deal, saying we'll accept this, then I will take that approach where I can because... yes, it may mean less fees for me, but if the client's happy, they'll spread the word. They'll say, well, actually, you get a good, you're not having a lawyer who's trying to run a case.
But you know what? That very thing you just said is, I think, what's unique about you, actually, because I think I wouldn't say the same about other dispute lawyers. I've had a couple of disputes in my life in the last couple of years and being a property developer, and I'll talk about one of them. But I don't see that as a mentality of every because they'll want to squeeze every penny they can out of you.
Yeah,
generally speaking,
there definitely is.
You are the exception to the rule, for sure.
Well, I'll take that compliment. I think what can sometimes happen with cases like this is parties get really entrenched in their position, and then they think, well, it's the principle of the matter.
Yeah.
And I say, well, okay, the principle's important, but if it's going to cost you 50 grand.
Yeah.
To see that principle out through trial for something that's only worth 35 grand.
What is the point, right? What are you going to achieve at the end of it?
What are you going to achieve? You know what? Good examples of those are neighbour disputes. So,
like what? So go on. So first, let's start off with what sort of disputes do you deal with? Like what can we come to you with?
Okay, so
hopefully nothing. But if you have a dispute, then what do we need to come with?
I deal with a lot of property related disputes. So I'll deal with landlord and tenant disputes, land disputes, which can that can be between.
So when you're
neighbours,
buying land and something's gone wrong.
Yeah.
Auctions.
Auction disputes, joint venture disputes, bridge and loan disputes.
So let's talk about each of these, right? Maybe we start off with landlord and tenant, for example. So tell us maybe one or two challenging or interesting cases that you've dealt with, and in the end you've won. So who do you work for? You could be the landlord or the tenant?
Yeah, generally speaking, it's usually the landlords we act for, but we do also sometimes act for leaseholders and tenants as well, depending on the circumstances. There's such an array of cases. You're a landlord yourself, so you'll be aware of obvious ones are, for example, eviction. So tenants who aren't paying, residential tenants who aren't paying their rent. Same with commercial tenants who aren't paying their rent as well, or paying service charge contributions. It will be dealing with Section 8 notices, Section 21 notices, which are now going. I'm sure we'll speak about that separately.
We'll speak about that in a minute.
And then general breaches of the terms of the lease. So if there's sort of antisocial behaviour or, there's such an array.
In both resi and commercial, right?
In residential and commercial, yeah.
But what's the big difference? I know you do both. So what is the difference in is it quite a lot different?
It's massively different. So residential tenancy disputes are governed by quite onerous legislation, which is only becoming more onerous. You probably, you are, I know you are aware of it.
Of renters' rights.
The Renters' Rights Act.
Freehold and Leasehold Reform.
There's the Leasehold and Freehold Reform Act. There's all of the previous, the Housing Act 1988, the Housing Act 2004. There's all of these pieces of legislation regarding HMO properties, which a lot of people are involved in, licensing requirements, health and safety requirements to keep the property in good condition. The consequences,
decent home standards,
which is going to come in to the private rented sector, but also the provisions around taking back possession of your property and how long that can take in residential versus commercial is massively different. So you could be looking at a situation in a residential scenario where it may take over 12 months to get a tenant out of a property
for non-payment.
For saying non-payment, because you're going to have to serve a notice. Then if they don't get out, you're going to have to issue a claim.
And there has to be, like in the new rule, 3 months of rent arrears, right?
Yeah, they've changed that under the Renters' Rights Act.
It was 2, now it's going to be 3. And then there's a notice period as well on top of. So let's say they haven't paid rent for 3 months, then you serve them a notice. Titans is a property education and collaborative platform, which is effectively a community of property professionals, investors, developers who like to come together, connect, engage, and help grow each other's businesses. Find out more, teamtitans.co.uk.
Exactly. Then you're serving them a notice. But then even after that, once you've served the notice and it has expired, you have to instruct solicitors, have them send in the claim to court. It needs to be issued. Then that court claim needs to be served on the defendant. At that point, it is open to a defendant to file a defence, which is not uncommon. You've probably heard of defendants who will file disrepair defences or argue that they paid some of the rent.
So what happens if they
then there's going to probably be directions for a trial. A final
with a date
hearing.
where both come into the
Both
court.
come in. And then the court will hear that. But a lot of these courts, so say the Central London County Court, it's packed, it's under-resourced. So cases can take a long time.
So your rent arrears are building up and building
Your
up.
rent arrears are building up and you still haven't got possession of your property. But if you compare that to commercial, then provided the landlord hasn't waived the right to forfeit, which can be slightly complicated, but assuming they haven't waived that right, they can instruct bailiffs to change the locks.
On like say first month they haven't paid a quarter, let's say, because I believe they're mostly in quarterly payments, right?
Yeah, a lot of leases now have quarterly payments, and assuming there is a forfeiture provision in the lease.
So what was the forfeiture provision?
So forfeiture provision states usually that if, for example, rent is unpaid for 21 days, usually it's 21 days, then a landlord has a right to re-enter the premises peacefully and take back possession.
So forfeiture is where you allowed access into the property.
You're literally allowed to terminate that lease. That act of forfeiture would bring it to an end.
Right.
And the only way that generally, as long as it was a lawful forfeiture, the only way to bring it back to life is by way of a court order. And in order for the tenant to get relief from forfeiture, they would have to pay all of the landlord's legal fees, any costs and expenses of the bailiffs that were paid to, go and change the locks in the building.
Right.
So you can see how in that scenario, the landlord's in a much stronger position.
Huge.
And
rightly so, right? Because it's his property. He's paid good money to buy this property, invest into it. Yeah. And if he's not getting his rent...
If they've breached the terms of the lease.
Exactly. They've breached and other things, I guess, as well.
Exactly. And actually those forfeiture provisions can apply not only in relation to non-payment of rent. So say, for example, a tenant is using the property in breach of the user provisions, or they've sublet the property.
Without having a sublet clause in it. Because normally you can sublet, right?
Yes.
But if you haven't got the sublet clause and the permission.
Exactly, and the permission, if you did that, or if you're breaching any other terms of the lease, it's open to a landlord to serve what's referred to as a Section 146 notice on the tenant, providing them with a reasonable period to remedy the breach. Yeah. And again, if they don't do that, it can be open to the landlord to, again, just forfeit the lease. And if the landlord wants to take a safer approach, they can forfeit by court proceedings. But quite regularly, landlords will now go in and change locks if tenants aren't paying. Yeah. And also just generally, and we were speaking about this before the podcast, if you think of full repairing and insuring leases under commercial property now, they are generally drafted in a way which is quite favourable to landlords. There's quite clear conditions on the tenants to pay the rent, pay a service charge, comply with user covenants. If there's alterations, they need to do them with consent. At the end of the term, they need to yield up and give that property back
in the same condition.
And if there's disrepair, then the landlord can serve a dilapidation schedule and potentially recoup the costs.
I mean, in my mind, I think the only way to invest in the UK property business at the moment is commercial, in my view. I might be wrong, but I think residential, the risk is too much. You're taking on a huge risk. Of course, we are landlords, and I think we haven't just talked about this yet, but you're also a landlord, right? Yeah. And when did that journey start? When did you start investing in property?
So probably when I first moved to London in 2006-07. So me and a friend bought a
buy-to-lets
or a property to live in ourselves, and then we had one spare room, so we were sort of letting it out.
Yeah, and then
that was in 2007 or 8, so just before the financial crash.
Oh gosh, yeah, thank God it was just before.
Yeah, and so from then on I've invested, I've done some JVs with people. I'll buy some properties at auction. I'm part of the auction buyers club.
And would you flip them or would you keep them?
Generally, I've flipped some. One of the things I was doing with my wife is that we would buy some stuff, live in it for a few years, do it up and move on.
Nice.
And now I know a common acquaintance in Jay Howard. So I think he's been a guest.
Yes, he has.
Hasn't he? And I'm part of his auction buyers club. So
you
which is
advise
really
for the legal packs and
we'll advise on them, and also if there's good properties that go, sometimes
then you'll invest in it and flip it.
Do something. So it's but that auction world is it's an interesting world in and of itself, because there's really good opportunities there, but there's also massive risks.
Huge. So tell us all about, I know you mentioned in the past, there's massive disputes when you're buying properties in auction, and some people can be very blasé about things and think, it's a great deal, but they've definitely not read the fine print and they've got into trouble. So tell us maybe about a couple of the auction disputes that you've seen, and what advice can people take or lessons people can learn from those mistakes that other people have made.
One of the first things I'd mention is, I don't know if you've heard this statistic, but David Sandeman from the EIG group has said around 40% of the people who bid don't read the legal packs.
Wow, so that's crazy, right?
Yeah, they don't even download the legal pack from the EIG platform. So that's taking a big risk straight away. And we've had so many scenarios where somebody in the firm, because we've got quite a large transactional team, and quite regularly they will send some client who's bought something at auction and had buyer's regret. It's just a bad deal.
So they've exchanged, but they're thinking,
I don't want this now. And often they will say, well, I just don't want it. Can you tell the seller? I said, well, no.
The hammer's,
it's the hammer's fallen.
And
we've been on the other receiving end of several buyers who...
remorse.
Buyers who've clearly got buyer's remorse, but try and raise, for example, misrepresentation. So what they will say is, the property wasn't exactly as advertised.
Oh, yes.
So you've misrepresented.
So how does that work? So when you've had people who, like the buyers, for example, coming to you, in any case, have you been able to reverse that and actually prove that there was negligence on behalf of the auctioneer or...
So not on behalf of the auctioneer. Usually the misrepresentation claim will be against the seller. Yeah. But often the misrepresentation claims are unsuccessful. So we're usually on the side of defending those claims, because there's buyers who really can't establish that it was actually there was a misrepresentation in the first place. But also what some people fail to appreciate is, not only does there need to be a misrepresentation of fact or law, but they also need to demonstrate that misrepresentation induced them to enter into that contract.
Right.
And they wouldn't have entered into it but for that representation.
So how do you prove that?
Well, for example, if they haven't even downloaded the legal pack, then how were they induced to enter into the contract? You didn't even read the pack at all.
Well, that's a straight black and white.
Exactly.
Really.
So a lot of them will then either have their deposit forfeited. And by the way, on several occasions, we have forfeited the deposits, but then you can also pursue the defaulting buyer for any further losses suffered by the seller beyond that.
And you've done that?
Yeah. And
successful?
Successfully achieved that, on several occasions.
Because like you said, if they hadn't bought it at that auction, then somebody else may have bought it. Or
Exactly. And if at the next auction it sells for a lot less,
you could claim the difference.
You can pursue the
difference. And people
difference.
are legally obliged to do that.
Exactly.
Do people pay?
Yeah.
They
on several occasions, they do.
So that's a huge, that's an easy one, right? Download the legal pack and read it.
That's a good starting point. And another one is, we were discussing this before, is pay particular attention to the special conditions as well, because there's often some
hidden fees.
Hidden fees. Quite commonly you will see fees, for example, of 2.75% for traders. They will have that in, a lot of them as standard, which is, becoming more common.
You have to factor that in, right?
You just have to be aware of it at least. Another one is that we've seen creeping in is rights for sellers to just rescind the contract at any point. And
so what does that mean? So sellers can... So even if you've sold it on the auction exchanged...
Exactly. The seller is still retaining a right to rescind that contract right up until the end.
So they can keep resell it...
So keep remarking, trying to...
get a higher price.
Trying to get a higher price right before it. So that
That's
is
crazy.
creeping,
That's a scary one, actually.
Yeah.
Can you imagine? You've gone all out to secure this deal, buy this deal, trying to organize finance and everything else that goes with it. And then...
And especially if, for example, you're intending to fund that by way of a bridging loan.
Oh gosh, can you imagine? You
Yeah.
already
You could have signed on the dotted line in
paid for the
respect.
valuations
Yeah.
or whatever. You know what I mean?
Legal fees. Yeah, exactly. So I think if you are going to enter into an auction contract, then it's definitely worth checking the special conditions carefully and the pack in general. Usually what I would say is have a lawyer look over the entire pack.
I mean, there's a lot of people now saying you can use AI, and
Yeah.
would you advocate that to start with?
Do you know
maybe?
what? AI is an interesting one. I know Jade Shrub-Soul has got DocuWise, and it is a good platform. You know, it does work because it will flag and highlight a lot of
And
these
there are some
common
other ones,
clauses.
like I'm using another one
Yeah.
called Ease AI.
Yes.
And they are amazing because I think they've got a maximum limit of 50 legal documents that they can analyze
Right.
within minutes or
Yeah.
seconds.
Dude, it's not something I think solicitors who just try to discount all of this AI are missing a trick because it's so powerful.
I don't think you can avoid it really.
You can't avoid it.
You work with it, I think.
That is the thing, and you need to be intelligent about it. So, for example, if you're getting a legal pack from Ease AI or
Yeah.
DocuWise, then read it to see, because there may be things that are flagged up there that immediately cause you to say, well, actually, I'm out of this deal.
Exactly. Or get legal advice at that point.
Go and get legal advice at that
Maybe
point.
don't do it straight away, but then I think what this does do, the software will help you maybe it's a numbers game, right? They help you do
Exactly.
volumes
Yes.
where you'd be able to, can you imagine reading legal packs like 30 of,
Yeah.
how many?
And also, not everybody wants to, especially for traders who are buying a lot of stock, they don't want to send every auction pack to a lawyer and spend
the numbers
that
won't
money.
work for them.
Because you're not going to be successful on, I don't know what percentage they're going to be successful on bidding. But yeah, you don't want to spend that on everyone. One thing I do notice though with ChatGPT as well is a lot of our clients, when they send me information about a case now, I can tell there's been loads of ChatGPT all over it. And it's about 6 pages long of instructions of what they want.
But that's a good thing. It points you in the right direction to start with. And then you can look into it and go deep dive into that particular topic.
I did have one over Christmas though, where a client, well, he wasn't a client of mine at that point, but he came to me afterwards. It was actually a commercial property where there was an eviction, so a forfeiture. But he had made an application for an injunction, but only used ChatGPT. And he ended up on the wrong end of quite a big cost order against them because the other side instructed lawyers, barristers,
the tenant, the commercial tenant.
The landlord. They were the commercial tenant. Landlord instructed barristers, etc. And it was not a good day out for him because some of what was in that claim was correct, but there was several fundamental errors. And so ChatGPT is useful, but it should be used together with
the lawyers, I think.
I think so, yeah.
100%. I think
if you're going to do injunctions.
Yeah, so injunction as well. So the tenant applied for an injunction, which means the landlord can't come into the property.
Well, no, they were applying for an injunction to get the lease back, to say it was an unlawful forfeiture and that they should be permitted to access the property immediately. Yeah.
Got you.
Yeah.
I think you're right. I think everything within reason. I think, use it to aid you
exactly.
and make you understand what the issues are overall, and then consult the lawyer.
Exactly.
Which I think will reduce your costs in any way because, like you said, it's a volume business. If you're looking at 10 legal packs a month, you might not need to buy. When you see some specific issues, like you might think, well, I don't want to go ahead with this anyway.
Exactly.
And then just pick up the ones that you think you want to go ahead with, right? So
another one that you mentioned earlier, which is probably worth mentioning as well, is joint venture disputes.
Right.
Because they play into there's a lot of joint ventures in the auction world, but
huge.
also
I've
the
done
property.
Quite a few, but luckily I've been okay. But tell us all about the ones that haven't been good.
Yeah, there's so many of them.
Oh, seriously?
A lot. So disputes between father and son, between
family.
Sisters, brothers, best friends, endless joint venture
disputes. Do they have
disputes.
any legal documents in place? Do they have like a shareholder agreement? Or
often not, and that is
the issue.
That's often the real big problem because generally speaking, if the projects go well, there usually isn't that much of a dispute. But when the projects don't go to plan, and there's additional costs or there's losses incurred if the property is sold for less than it was anticipated, then there's a major risk that one party might turn around and say, well, I'm not paying for this.
I don't have the money.
I don't have the money. Exactly. We've had on a few occasions situations where, I'll give you one example. You know Stuart Wyeth, don't you? So,
yes.
And he's brilliant at doing, for example, bank conversions.
Commercial to resi.
Commercial to resi. He knows what he's doing.
Yeah.
He does it really quickly.
Absolutely.
So I've had examples of where people will try and do something similar, but just without the requisite skill set to do it. So they'll try and let's do a bank conversion. We've seen them on social media. We'll turn this bank into nine units, easy, and we'll make this GDV. Where in practice, what I've seen happen is if they don't have the experience of dealing with bank conversions, for example, then
it's quite challenging. I've done two myself.
You've done two, yes, you know. Then I've seen situations where lots of remedial work are required. The money has ran out, bridging loans involved, and money called in, potential bankruptcy proceedings as a result of that. So scenarios where you do joint ventures with a partner who doesn't have the sufficient experience to carry out a development.
Yes. So let's say, would it be like one investor's put in all the money and the property person is the experienced person, so-called experienced person who's going to run the project, effectively
That's usually how it works, isn't it? You have one putting in the money and the other one managing.
Time and sweat equity versus money, money, right? And then the person is lied about it or
just not able to fulfill their end of managing the project. So that's quite common. And then you run into difficulties with financing as a result. So
what happens in the end? Like, give us one or two consequences, or what has been the end result in some of these?
So what tends to pour fuel on the fire is bridging loans combined with joint ventures, combined with a lack of experience.
You're under time pressure.
You're under time pressure. So if those projects don't complete when they're supposed to complete, then the bridging company
knocking on your door, right?
They're not going to be that understanding a lot of the time. The bridge is up.
Unless you have a relationship with the bridging company and they are friendly.
Yes. If you have if you're communicating with the bridge,
then it's okay.
It can potentially be okay. But often if there are issues with the development, then the bridge and loan company are likely to get nervous as well and say, well, do you know what? I don't want our loan to value here continuing to get close to the maximum level. So we're calling in our loan, pay it, or we're going to appoint receivers.
Yeah.
We're going to sell the property. And the difficulty is...
And it's halfway through the construction.
So then what you can have is, let's say you have a property with a GDV of $1 million. You've already spent 600. Actually, they call in the loan. Now you're selling that property at 400,000. So there's a 200,000 shortfall. So who's paying for the shortfall?
Yeah.
And the reality is, usually the bridge and loan companies will have joint and several liability of the directors
PGs, right?
on the personal guarantees.
Yes.
And so whoever has the money...
Money, because the investor has the money and the sweat equity person doesn't.
Usually doesn't, yeah. And you can sometimes find if sufficient due diligence isn't carried out on both partners, then you can have scenarios where the other partner has county court judgments against them.
Yes.
They've no assets.
No.
They've got nothing to lose.
So would you say that if before getting into a joint venture, they come to like yourselves, RFB, and you would help in the due diligence process as well?
Well, we would certainly, we would draft, first of all, we would say draft documents and shareholders agreements or joint venture agreements to set out what parts of the venture is each party going to be responsible for.
Responsibilities, roles, and all of those.
And are they going to be paid? So if somebody's managing the project, what's their remuneration going to be? And what happens if one party wants to exit quicker than the other?
Yeah.
So
you look at different scenarios and you come up with something that's what both the parties are happy to agree to.
Exactly.
Right.
That's
but
the
at least
idea.
they've thought about it, right? You've had to go to them with these scenarios.
Yes.
They've had to discuss it.
Yes.
Come to an agreement, And then you know at least then they're on the same page.
Yeah, what is the exits going to... So what are you going to do at the completion? Is it going to be rented out?
Sold.
Are you going to sell it?
If it doesn't sell, then what are you going to do?
Yeah, exactly.
All the various scenarios that you can
who's the letting agent that will be appointed? Who's going to choose that?
Yes.
And what would happen if there's two partners and they can't agree on something? How do you determine who gets it? Is there going to be a casting vote? Is there going to be an independent person? Yeah. So you need to work out what would happen in the event of a deadlock.
I just want to give a quick shout out to my new sponsor, Inflow Finance. I'm genuinely happy to support them because I've worked with them myself. If you are a developer, investor, or broker looking for refurbishment, development, or bridging finance, then Inflow is the right lender for you because they truly understand property. Do reach out to them via their website, inflowfinance.com, or scan the QR code below. But I think that's good because, like you said, if you don't have the answers to these, then maybe the joint venture can't go ahead.
Exactly.
And if you can't agree at that stage...
I think it's because also what we have found in a lot of joint venture disputes is that when it's all done on a handshake and on trust, when things go wrong, people's recollection of what was agreed at the start changes. And so you'll often have one party saying, well, this was the agreement. And the other, no, it was not the agreement. The agreement was X, Y, and Z.
Yeah.
And they just completely cannot agree. And if you think from a point of view of a lawyer, if we have to then litigate that matter, it's going to make it so much more complicated and difficult because
there's no paperwork.
There's no agreement written down, no paperwork to...
Oh, yes, they have a company and they have shares and all of that. But how is that going to decide who was meant to be doing what?
Exactly. Yeah, so it becomes... And even that became an issue in one of the cases we had between two sisters. And at the end of it, they couldn't even decide who they would appoint to dissolve the companies. It had to be dissolved in the end or entered into insolvency. Yeah. And they were arguing about who would get to choose which insolvency practitioner will be appointed. So
and they were arguing about just
that everything. So there is, I think there's a question to be asked about, well, the person that you decide to do a joint venture with, are they going to react how you'd like them to when times get difficult?
Values. I mean, you'd think two sisters, the values would be very similar, right?
Yes.
And, the end goal would be very similar. But like you said...
Well, what you can have sometimes is just different personalities. If you compare your sisters, some are quite conscientious, others a bit more laissez-faire. And so that approach in property joint ventures can lead to... In
fact, I think it's worse when it's with family, actually.
It can
because you kind of look at them in a different light even. It's a different kind of like, you know them as your sister, your brother, cousin, whatever it is. And then you kind of discount their whole professionalism,
Yeah.
I don't know. It's just a kind of weird little thing where I feel that's not the right way to go anyway.
There is risks attached to it because even, for example, with fathers and sons, what I've seen in the past is a venture going really well. And then, for example, the father turning around to the son and saying, well, the agreement actually is that all of this business now belongs to me. The properties all belong to me because I'm the father, you're the son. And so that's how it's going to go
to the son anyway, or the children.
It is, but we've had cases run all the way to the High Court with massive legal fees involved between a father and a son on business joint ventures, and the paperwork isn't great at the start, and it causes issues, and it leaves scope for parties to argue because one side is when property joint ventures go wrong, but also when they go very well. So we had one where there was a commercial property. It was bought by an experienced property investor and another lady who just put in her money. She had the liquidity. When they realised that the value of the property went from, say, 1 million to 4 million over the course of several years, the property investor turned around. He was on the third set of lawyers when he came to me, but basically what, in my view, he was trying to do was find a loophole in the agreements that they'd reached so that he would get more of that money.
Oh my God.
Yeah, and he had several lawyers pour over this agreement.
He wasn't the one who put the money in? Or
he didn't put the money in, no.
And he was still trying to get more
and there was, because he drafted the agreement as well.
So there was an agreement.
There was an agreement, but he was trying to interpret that agreement in a way that was much more favourable to him, and also in a manner he was trying to argue that there was no requirement to sell the properties and distribute the proceeds.
Yeah. So he wanted to retain it.
He wanted to retain it, and so then this had been tied up in litigation for 3 or so years. And
how much money were they racking in for legal fees?
Quite a bit, because he was, as I say, he was on his
3 years is a long
third
time.
lawyer, and he went on to a fourth lawyer after me. And I think the issue there was that actually it was a victim or an issue where it was doing so well that this property investor thought, well, actually, I feel like I'm entitled to more of the pie here. And so
he probably blew away all his profit in litigation fees anyway, in disputes.
No, there was enough. There was still enough.
But even then, he could have kept a much bigger chunk had he not blown away, X percentage of it on.
But it does demonstrate that when you're entering into these agreements, having really clear demarcation about what each person is entitled to at the end is so important, because when it goes wrong or when it goes really well, human beings are incentivized to act in their own self-interests if they can.
But, it's quite scary, actually. But I think it's great so people know about this, right?
Yeah.
A, don't get into a joint venture with a family member for sure. B, don't do residential property if you don't want to. But on the sort of positive side of things, there seems to be a huge uptake of residential landlords and developers moving into commercial. How are you finding that? Are you finding that within your... I know you don't do conveyancing, but in your practice as well as
we
large?
are. By the way, on the family point, I have seen some examples of families where their property ventures go really well together. So there is some, even in our clients, there's some really successful families. But in terms of commercial and resi, what we see a lot of clients doing at the moment is going for mixed use properties. So you will have, generally speaking, commercial on the ground floor, residential on the uppers, and either they're converted into HMOs or developed upwards.
Or even service accommodation.
Service accommodation, yeah. The one advantage to short-term lets, I suppose, in some areas is that you avoid the renter's rights act.
Yeah,
because it won't amount to an assured short-hold tenancy or an assured periodic tenancy when that comes in.
So, we're talking about all these different, regulations coming in. You've also got the Freehold and Leasehold Reform Act.
Yes.
And we know that it's been law for a couple of years.
Yes.
And there's been a certain aspects that have changed. So you can issue the Section 42, I think?
Yes.
Immediately, as soon
as you become the registered owner, yes.
Versus 2 years you had to wait before, right?
2 years, yeah.
So what is this new thing with the marriage value? I know that's still in process. It's not changed. So
it's not changed.
It still will cost you hundreds of thousands of pounds to renew a lease in certain cases, if depending on the uplift of the value. What's happening with that? Is there an update to that yet?
Yeah, so to me, it's a bit like the government has answered the easy questions in the exam, which is, abolishing the 2-year rule, which isn't that controversial, is it?
Yeah.
And a few other things that they've done. They've changed the non-residential requirement from 25% to 50%. But
so what is this non-residential requirement?
So previously it was the case that if there was a property which it had to be less than 25% of that property was commercial or non-residential in order for it to qualify. But now they've expanded that to 50%. So if you had a building which had, say, 48% commercial, it's now open to the tenants or the leaseholders to exercise enfranchisement over that property, so they can still do it now. It basically brings in more properties to the scope of enfranchisement. But yeah, sorry, what was our question?
So the question was this marriage value.
The marriage value. Yeah, so on that, so they've sort of answered the easy question, but I think you're probably aware that there was a group of freeholders and some pension funds that made an application to, I think it was the High Court, to challenge.
Arguing it, I think, right?
Yeah, they were challenging that the legislation breached their human rights because it interfered with their property rights and their basically their money. It's taking money out of their pockets. They lost, but they've applied for permission to appeal, and that could take who knows, 2-3 years.
Right.
And so the government hasn't, as far as I'm aware, they haven't even started the consultation on the valuation methodology and how that's actually going to be changed, because at the same time we've got this ongoing legal battle in the courts about the Leasehold and Freehold Reform Act. So in reality, I don't think we're going to see a change for
at least a couple of years.
At least a couple of years.
So would you say the leasehold, buying a leasehold, short lease property and then increasing the lease and then adding the value that way is still a strategy still?
Yeah,
still
I know Jason Patterson, for example, he's
a master at it.
He's
right?
a master at it, and he's still doing deals.
Doing it.
Yeah. And a lot of our clients.
So there might be just shorter window of opportunity, right? Couple more years, maybe.
Well, the thing is, some people are waiting because they think for leaseholders, the idea is, and the government's intention is to make it cheaper for leaseholders
to renew.
To renew. And so for some people, they may think, well, actually, I'll buy a short lease, I'll wait 3 years. By that point, hopefully the government will have implemented those changes and I can get an even cheaper lease then.
Yeah.
But we don't know.
There's no guarantee.
There's no guarantee as to what exactly that new valuation methodology will be or when it will come in. But the other thing the government has done recently is they have announced a cap on ground rents.
Right.
A proposed cap on
for
ground
future,
rents.
but not for the existing ones.
Well, so they've already capped for future ones, but what they're intending to bring in as part of the common hold reform, a cap to £250 per annum. And after a 40-year sunset clause where it will then go to zero after 40 years.
Right.
So that will be for all leases.
Yeah.
But we don't know when that will come in.
It'll be for all leases and existing leases as well.
Existing leases as well.
But will the existing leases then become common hold? No, it doesn't work that way.
No, it's a good point. Separate to that, the government is also proposing to abolish leasehold flats as
completely.
well. Completely.
So the concept of leasehold will disappear eventually if this bill comes into law.
Yes, exactly. So that's another proposal that that the government have said they're going to implement.
So what would happen then? That would be for the newer apartments that are built, right? What about the existing ones which are under the leasehold?
Yeah, this is what we're waiting to see the details of, because that is going to be, a complicated system to work out.
Because they can't just say, existing leases can just become common hold, because automatically that means that the tenants, the lessees get.
Exactly, they would get a windfall if you had a 10-year lease and it immediately became a unit in a common hold block. Then they would get a massive
990 a year. Yeah. No, there wouldn't be a lease.
It wouldn't be a lease. Yeah, it is a weird concept to understand. So there's going to be, it's going to be quite a transition, and also I think their idea is that they will do this by 2029.
Right.
2028, 2029. That feels ambitious to me because it's going to be such a massive difference.
But isn't it like share of freehold then?
Exactly.
Common hold is like share of freehold, right?
Yeah, like it's similar to share.
Because you own a part of the whole.
The idea would be you own a unit of the whole thing.
In relation to like a percentage of, depending on how big it is. Will it be like a 1-bedroom might have a smaller percentage versus a 2-bed, I guess?
Yeah,
something like that.
Well,
right?
Yeah, I don't know exactly how they're going to work it out. I know they've got this model in a lot of other countries, so the government are probably
looking at learning from all the other Australia, I think. Isn't it?
Yeah, they're looking at a lot of those and deciding how exactly they'll implement it.
So going back to like the UK property law, I mean, we've got a definitely advantage over a lot of other countries in the world where we've got this title register, title plan, and the red line, as they say, is what you're buying, right? And you've got certainty of what you're paying for is what you're buying within that red line.
Yes.
What are your thoughts on just generally the UK property law versus maybe other countries, and do we have an advantage, you think, in this country because our law is so?
We do. Yeah, I think we do. Our law and our legal system is strong. We've got an entire judicial system that's based on fairness. And generally speaking, they're really well trained, excellent judges who are able to decide matters fairly. So you can be pretty confident if you buy a property in the UK that your rights are going to be protected, generally speaking, which is an advantage. It gives people a sense of security.
Security, right? That you're paying for what you get. But then again, there have been disputes. So I remember I bought a land with planning permission, and it was the access into one of the houses there was a bit of land which didn't actually belong to the bit of land that I was buying.
Right.
So although on planning permission terms it was fine,
Yes.
that it showed, okay, this is it, your access is through here, but the bit that they were accessing it through was part of another property next door.
Yes.
So what we then found is we had to hire a party wall solicitor?
Right. Yeah.
And party wall surveyor.
Yeah.
But then we also had to then buy the land of this neighbor, which it turned out okay. We had to pay, I think, a couple of £1,000.
Oh, right. That's
but
not
the
bad.
stress of knowing, oh my God, you can't, like, you've only known this once you've exchanged and you're thinking, well, what do I do now?
Yes.
So how do we avoid, like, a developer who's maybe had historically done HMOs now wants to do ground up and is buying, developments? What sort of, have you come across these firstly?
We have. We've seen that this arises in auction properties in particular as well,
Right.
because usually if it was a normal conveyance, you would expect your lawyer to pick up those issues and advise you, well, actually, you've got this strip of land which isn't belonging to you, which you need for your development. But recently we had a client who bought a property at auction, had carried out a development of a beautiful house, and right at the end of the development, the neighbour knocked on his door and said, by the way, do you know that I own the strip of land right at the front in order to access your property? And the client obviously didn't know that, checked the title documents, and the neighbour was correct. The neighbour had obviously deliberately waited until the developer had completely finished the project to bring this fact to his attention.
So all throughout the construction, they didn't mention it, nothing?
No.
And then?
No.
Ransom.
It's going to be I think, yeah, he's going to. So we said we could look into it for him, but I think what he's decided himself is
pay
that
him off.
he's going to have to pay this guy.
Could be
but it won't be what you were talking about. This wouldn't be a matter of
$2 or $3 grand.
No, it won't be 2 or 3 grand. You might have to add a few zeros on because,
But then again, it's funny because the conveyancing, although you exchange on the day when the hammer falls, you still have the 4 weeks or 6 weeks sometimes.
Yes, but you're contractually bound to complete.
Anyway, but what I'm saying is if you find out and you think, well, is it worth me losing the 10%?
Yes.
You can make a decision.
You can make a judgment call at that point. Exactly.
Or reach out to the landowner and say, well, look, we've bought this without knowing the full story and therefore would you take, X amount or whatever.
Yes.
And then at least you can gauge what the ransom strip, payment is going to be and
it's
then
true.
make a decision based on that.
Yeah. And it may be, there's a judgment call because I suppose that person could then sue them not only for the deposit, but for any difference in a shortfall if he has to resell that property. Because I guess if people are checking that legal pack correctly, they would notice that this plot of land, the access point.
So you've come across a lot of these, I guess.
There's a lot of this.
So I think...
And you also get adverse possession type situations.
To tell us a little bit more about that?
Where somebody, for example, has used the plot of land or, enclosed it and treated it as their own and exclusively possessed it and prevented anybody else from using it.
Occupying it or whatever.
Exactly, for 12 years, then they will often make an application for adverse possession to be registered as the owner on the basis that they've been using it exclusively themselves. And then they can. We've been successful on several of those.
Amazing. So what are you saying? Go and find some empty properties which have been empty for years, and then go and adversely occupy it, and then.
Another one is with lease extensions. Sometimes I know you mentioned this previously. Was lease extensions where the freeholder is absent.
Yes.
Those can be a good opportunity, and we've cases for clients where they're able to demonstrate that the landlord is missing, apply to court for a vesting order, go to a tribunal and provide the evidence of what premium should be paid. Sometimes we're able to get the legal costs deducted off the premium.
So this is where they want to extend the lease and the freeholder is absent.
Yes.
And then?
Or purchase the freehold, as a group where the freeholder is absent.
Right.
And then you don't have a surveyor acting for the freeholder because they're absent. And so you can get good outcomes in terms of premium, get a deduction on legal fees. On one occasion, we were also able to have the lease interpreted in a way where the loft was included. So that was an additional benefit for our client. So yeah, those can present some opportunities, but it requires a little bit of work because you have to go off, you advertise in the local gazette.
But these would probably be more on the open market rather than...
Or it depends. You see them in auctions, you see them in the open market, where some landlords have, I don't know, they've died or gone away. Or
it's been historically they've owned it, but like I said, they are, people who've taken over from their legacy, they don't even know about it.
They don't know about it. They're uncontactable. They've moved to a different country. Yeah.
It happens all the time.
It does. And someone still, usually what will happen is maybe the leaseholders are insuring it, the leaseholders are maintaining the building, so it's clear this landlord hasn't been on the scene for years.
But I get there's a lot of obviously disputes, and we're only talking from this point of view because obviously you're talking about but there's huge opportunity in property, right? But what I fail to understand is that the government and the political, not just the current government, but previously governments had, we had this perfectly amazing property world where every 7 years the property would double in price, and gone are the days, right? Because the prices are pretty much flatlined, and there seems to be this wider political agenda where they seem to be changing things a lot and adding more and more regulation. And where do you see from your point of view, like, is this ever going to end? Because it's like...
You're right. There's definitely a macro legal trend of increased state intervention in the UK property market. To speculate as to why that is, I suspect the government probably want more institutional investors in the private.
Do you think there is
sector.
a drive somewhere? They talk about the World Economic Forum and sorts of agendas going.
I saw in Savills quoted, I think in a research paper in 2024, that the private rented sector is worth about 1.6 trillion and the institutional portion of that is about 2%.
Is that
2024
in the UK?
But I think and I know even recently, I think it was at the end of December, it was announced that there was, I think the National Pension Service of Korea was investing in a joint venture worth about £1 billion into the property sector in the UK. Property. Yeah. And that's a bit like it seemed a bit like an institutional seal of approval for other institutions to start, dipping their toe into that market. And I suspect this increased regulation and the intervention of the state is pushing the market towards institutionalization.
Which is a shame, really, because the SME market has shrunk massively. I know that there was a need for maybe some of the old school landlords to actually change their ways and, have better quality accommodation for tenants. Mm-hmm. And tenants deserve, obviously, good quality accommodation. But I think they've gone too extreme, and to the extreme where they've kind of shrunk the PRS more than it ever needed to,
Yeah.
Not only...
Well, one of the things I know we discussed when I was at your Titans event recently was there's a clause in the Renters' Rights Act now where, because you can't serve a Section 21 notice anymore, one of the grounds, Section 1A, is that if you have a genuine intention to sell your property, you can serve a Section 8 notice.
Right.
But one of the provisions in there states that if you serve that notice, then you're not permitted to relet that property for a period of 12 months from the date in the notice or later if you've issued a claim for possession. And that's even if, for example, there was no fault of the landlord in not
selling. The sale just fell through, right?
Just fell through. If it was absolutely no problem of the landlord and the buyer just walked away from the deal.
Absolutely.
As they sometimes do.
It happens all the time,
It happens. Then I'm not sure why it's fair that a landlord shouldn't be able to relet that property for 12 months.
I know.
If they genuinely intended to sell and it was, let's say, for example, the buyer dies or the buyer has a financial issue.
Or an accident. Yeah, exactly.
Then, and you didn't have anybody else lined up. I suppose you could keep trying to resell. You just have to start marketing again and reselling. But it seems harsh to me to prevent landlords in those scenarios from reletting the property for 12 months.
I think there's lots of these harsh clauses in the new renters' rights, but I think we could talk about it forever.
We could.
But do you think you yourself, because I know you said you invest in property, are you just doing commercial property now? What's your personal sort of property investment journey? I would probably
prefer to pivot, I think, at the minute I'm more in residential. We did actually, our firm and the partners in our firm purchased recently a building in Holborn, which is commercial, which we're quite excited
about. So
an
office where?
An office, yeah. An office in Holborn.
So you're occupying a large office building now instead?
We're occupying the lot because the rent was so high, we thought we might as well buy it and pay instead of paying the rent. But generally, I'm faced with the same problem that a lot of landlords are. So the Renters' Rights Act comes in on the 1st of May. So I've got a question in my own mind. Well, with any of the tenants that I'm not convinced about, should I serve a Section 21 notice now with a view to taking possession of that property and trying to resell?
Yeah.
The market isn't that great at the moment.
Especially for apartments. I think if you've got houses, like, I don't know if you know the numbers. I was reading in Adam Lawrence's Sunday supplement, which is so amazingly informative. He said that in 2025, 1.7 million was sold subject to contract, of which 1.2 million sold. So there was a huge, massive number of transactions happened, but obviously we know at a reduced price, right? Because we know the asking prices had to be reduced.
Of course.
I think by around about 14 to 15% at an average, some more, some less or whatever. But I think transactional wise, we're doing really well. But I think you're having to drop your prices quite a lot if you want to sell.
You are.
And apartments aren't doing really well either in terms of selling.
Yeah. And I think for a lot of landlords, I know even this week I've had several landlords considering, for example, serving 21 notices on maybe 7, 8, 9, 10 apartments.
Which wouldn't have happened normally if they didn't reduce the Renters' Rights Bill.
You wouldn't know. It's because of the Renters' Rights Bill.
And it's funny because they're actually achieving the exact opposite of what they wanted to achieve.
Yeah,
they wanted to give tenants a fair hearing, which I think, and professional landlords like you and me, we've always maintained. We've spent £200,000 on a refurb for a HMO conversion. I mean, what's there not to like? I think some of the HMOs that we've got are better than our own house, you know? You end up scrimping and saving in your own house and you spend more money in the HMOs to give them a good quality accommodation.
And they will be subject to the minimum energy efficiency standards
I think we're okay because my properties have only been the last 10 to 12 years. So because we've upgraded them, they're generally at C.
And that's, I think, the landlords who will probably do better. The ones who have invested in their properties already, the landlords who've got systems in place, who've got their procedures and have got teams behind them that can deal with compliance, energy efficiency, sustainability.
Tenants and dealing with tenants as well is a big thing, right? And also I think what could really work well is that if maybe if you've got the appetite, that is, and if you want to retain your portfolio, if it's giving you a good cash flow, then having that relationship with the tenants possibly.
I think it's massive.
I think today, going forward, more so than it was in the past, I think.
Yeah, because what you can do, if you have a good relationship with tenants, instead of having to serve Section 21 notices...
Have a conversation.
Yeah, exactly.
Say, I want to do this, X, Y, and Z.
Yeah.
My plan is to sell it or whatever it is, and then...
Yeah. And I'd recommend doing that before the 1st of May. Though, if you were doing ones,
Yeah. No, I think there's still huge opportunities in the UK, but I think maybe pivoting to commercial is probably the way to go for residential landlords.
And the thing is, I know, speaking of Adam Lawrence, he had referred to, I think, the golden quarter, didn't he? Which is this quarter of 2026, where I can already see a lot of landlords coming to our firm wanting to sell. And so there's definitely going to be more properties in the market from exiting landlords.
Yeah, portfolio landlords.
Portfolio
and
landlords.
And they're not like just the one or two. We could buy huge portfolios.
Yes.
And if you are clever about it, so let's say you're buying it within a company.
Yes.
You're only paying 0.5% stamp duty.
Yeah.
And then maybe you can agree. I don't know the exact how it was done. Some people are just doing lease options on those portfolios.
Okay.
Where they pay the landlord or they agree to pay them in the future. So with an option to buy. So they lease it now with an option to buy in 5 years.
Yeah.
But then what they'll do is they'll pay them with the cash flow of the property, which then goes towards the purchase price.
Ah, clever. There are some
There's
creative
all sorts
deals.
of creative stuff that you could do, I think.
Yeah.
And does your firm deal with all these creative strategies, lease options, assisted sales, vendor finance? Exactly. I think that's where there's a lot of opportunities because what I'm noticing as well, and I'm looking at a deal right now, which was direct to vendor. They're looking to downsize. It's an older couple. And they've got some land at the back. It's just a very long garden with potential to maybe create 2 houses at the back. But they want to kind of move and they want to, because they've got these 2 semi-detached houses next to it. And there's just the 2 of them. They're like, it's too big for us to try and even maintain it.
Yeah.
And they are possibly going to do vendor finance with us. We haven't signed on the deal yet. But what I'm trying to say is that's another opportunity, I think, today. creative strategies.
Being creative with those with good deals, because I guess it's working out what do the sellers actually want. And how can I satisfy that and create a win-win scenario.
Yeah. So in this situation, what we proposed is we'll pay you X, and they were happy with that number.
Yeah.
But on the day of completion, they'll give us a loan for the deposit amount.
Okay.
We'll just do a buy-to-let. And then for the planning at the back, we'll just do subject to on that top-up bit, you see?
Okay, yes.
So they'll get a X amount of price, so then that'll help them leave the property, downsize, and move to wherever they want to.
Yeah.
And they'll have 70% of the money, 30% they'll give us for our purchase as vendor finance. And so for us, it's a no money down, but then we pay them an interest on their money as well.
Yeah.
Because you'll obviously have a loan agreement. So there's all sorts of creative stuff that we can do.
This is why you've won the Property Investor Awards, isn't it?
Not
It's
really.
These creative deals.
That was for, I haven't won it for a creative deal yet, but I think this is the right time in the market, I think,
It
to look
is.
at, exiting landlords, accidental landlords, and landlords who are wanting to move to Dubai.
Yeah, because the thing is, there's still, for SME landlords, they still do have advantages over those big institutional landlords, because what I find is sometimes those larger institutions, their asset management, because they've got such large portfolios, they just don't care about it. It's only...
They don't care about individual tenants and stuff, whereas landlords, I think, do.
They really want to maximize. Individual tenants who then come in and get, say, 4 or 5 properties really want to asset manage that and get the yield up.
But do you really think that the corporations would want to buy a row of Victorian houses, or would they be more interested in like a large co-living scheme or a build-to-rent?
Exactly. I would have thought. So, for example, in those deals, my understanding, you would think they're going more into the build-to-rent type market, or at least just building from ground up, new developments, etc. Because the government are proposing, aren't they, I think, to change the planning and infrastructure
Act,
so to bring that into effect to basically make it quicker and easier to get planning, and for, I think it's
near railway stations.
Yeah, but
800
I think they
meters.
call it and also nationally, or what is the
sustainable locations?
Something. Forget the exact phrase.
Is that already come in now? I think in December it came in, right?
Yeah, it's due to. I'm not sure if it's actually came in yet. No, it's proposed. There's one. I forget the exact name of the planning bill, but
I think it's called Planning and Infrastructure Act.
Yeah, I think that's the one. Yeah.
There's loads of different changes coming in that as well.
And the idea being to assist the government in fulfilling this plan to have 1.5 million new homes built within 5 years.
Well, they're already in their second year, right? So I don't know how they're going to... That's never going to happen. But if they can help towards that target, I think it'll be good to watch that space. And that's another area of opportunity as well.
It is. But again, I think it will be for the developers who are properly ahead of the game in terms of knowing what the national planning policy is, the local planning policy, and being able to work towards those, probably being able to provide sustainable or eco-friendly housing and homes.
I think there's all sorts of opportunities in the market. I think, like you said, maybe pick one, try it out, do 1 or 2 projects in that. And earlier on, I was speaking to Hayley Andrews, and she's just gone completely commercial. So she's doing asset management.
Just went all commercial?
Yeah, she's doing like Fun City, where she's created this massive entertainment center by buying an old museum, which was vacant for 10 years. So regeneration projects as well.
Yes.
There's huge opportunities, and especially up north and Midlands upwards, where there's a lot of town centres which have not been doing very well in the last sort of 8-10 years. So repurposing those and bringing back footfall in, bringing back adding to investing in the local economy, really.
Yeah. Would you like to get rid of your own Resi stock?
Well, that's bread and butter at the moment for me.
Yeah.
But I think eventually I probably will. But my focus this year is just commercial to asset management as well. I want to do
because the one thing about if all of these landlords are exiting or a lot of landlords are exiting the residential market, it will be interesting to see what, if any, effect that has on the rent.
Yeah.
In these
I
areas.
think the rents might go up quite a lot. But then I think there's a point where tenants can only go up to
to a certain level.
How much can you if they have salaries, I don't know, 40 grand, they can only pay like 800,000 pounds or whatever it is they can pay, right?
It's true.
So I think that will also decide the affordability, I think, of that tenant.
Yeah. It's going to be interesting to see how also what's going to have an effect is the financial penalties that landlords are going to receive as a result of the enforcements that
rent repayment orders.
Rent repayment orders. So that has been doubled. So the ability to give those rent repayment orders can now stretch back 2 years, and they can impose a 2-year rent repayment. It was previously 1 year.
I think if some of those start to come in, I think you're going to see a lot more landlords selling up.
Well, it could wipe out an entire 2 years rental
stock.
income.
Yeah.
So then why would landlords?
No, what I mean is it'll wipe out the PRS sector possibly.
Well,
right?
it could.
Can you imagine though?
It's definitely going to have some sort of impact as those financial penalties start filtering in, because those local councils are going to be able to retain the funds from the financial penalties that they impose on landlords. So it will be in the council's interest to find and fine landlords who have breached the legislation.
I think there's all the more reason for going commercial, right? But I think as this starts hitting home, you'll see more landlords exiting the PRS, and it's going to get even more squeezed, I think.
It will, and then there will be opportunities for the likes of maybe Adam Lawrence, others who are really on the ball, who can spot good opportunities.
Systemised to the T.
Systemised. You've got people like Des Taylor, on your team who are dealing with the compliance side of HMOs, etc. It can still, I think for some teams and for some people, they will be able to make it work in both residential and commercial. Huge opportunity there,
especially a lot of people who are looking to, it's a quantity, it's a numbers game for them, and they'll sell it to a REIT, for example.
Yes. And the thing is as well, there isn't enough homes in the UK.
No.
So there's a fundamental shortage of supply. And so you would imagine rents will still maintain at a good level, even for 1 beds and 2 beds.
But like you said, 2 years of rent could be wiped out, right? By one fine or rent repayment order.
The other thing is, if you want to now, after the Renters' Rights Act comes in, if you're wanting to get possession of your property, the length of time it's likely to take is going to be longer, because the courts are probably going to be busier.
Yeah.
It's not going to be straightforward Section 21s. The tenants may well try and drag these cases out. And so you would need to probably factor in the potential for greater costs of regulation, greater professional fees.
Yeah. So unless you've got a numbers game, I think, unless you've got a volume property game,
I think they're at an advantage. I think if you've got a portfolio and you've got a team that's efficient and has got good systems, they're definitely going to be at an advantage compared to an amateur landlord. And
building that relationship with the tenant, I think, is equally important going forward if you are continuing to be a resi landlord.
Definitely.
But for me, I think definitely I'm not selling quite yet. I'm on the fence right now.
Are you? Which I think there's quite a few people in that zone. I think
they're thinking about it. They're waiting to see. It's scary. I know it's scary, but I think, like you said, it might hit us all, and we might want to sell. But also the other thing is, right, you might have to. If everyone looks to sell, then you'll have to take a massive cut.
That's the thing.
That's the thing. You see what I mean? So I think it's that balance.
It is that balance, and because we're just coming out of a high interest period, aren't we? So and the rates are starting to creep down again. So I think probably there's some landlords who would prefer that to continue going down and then sell when the market's a bit stronger.
Yes, that could be it actually. Like if, they held rates, I think, didn't they, yesterday? They held or something? Rates, yeah. But they're saying there's probably March. They're expecting a cut. So at 3.5, that's pretty decent. I can't see it going much below 3.5 or 3.25, right?
No.
But no, I think it's been amazing talking to you, actually.
Thank
you. I think we've highlighted lots of opportunities. There is obviously a lot of issues, lots of disputes, but I think what I can take from my conversation with you is just be very careful. Involve a legal team when you need to involve them. Don't take shortcuts, especially when you're doing auctions, when you're doing bridging. Land disputes can be...
And JVs.
JVs, those are the 4 areas, but I think we've talked about lots and lots of opportunities. But personally for you, what's your vision for the next sort of 3 to 5 years?
John, I'm a bit like you in terms of I've got a vision professionally. So in terms of the firm, we're really wanting to grow our firm. We've moved into that office in Holborn. Oh, well, we're moving on Monday to office in Holborn.
How big is your team right now?
So, the firm itself is probably about 140 or 150 people in it now.
Wow.
But we really want to grow that. I want to grow my own litigation team.
Absolutely. How big is your team at the moment?
I've got about 10. We've got about 10 in our team. And so I'd like to, give opportunities to the people who are, in the team to continue to sort of expand,
to grow as well,
grow and specialise in areas. And then with property, I'm a bit like you. I'm on the fence as to what exactly I'll do. I'm going to sort of watch the space. But maybe go more into commercial? I think so.
Yeah. Definitely.
Yeah, we've obviously with the office that we've bought, we've now sort of jumped into commercial, and I'd like to, I think, do a little bit more in that space.
Yeah, that seems like a great opportunity you've got there.
Yeah, it's I'll bring you to the building. You'll have to pop in when you're there.
In your podcast studio, hopefully.
Yeah, exactly.
Brilliant. And I wish you well with your personal sort of investment journey as well as your RFB. But I think all I'm going to say is if anyone's got a dispute in property, they should reach out to you, because if nothing else, at least you're friendly and you can make us feel comfortable in that stressful situation where people are into disputes and what have you. So thank you so much for taking the time out today, and really, really appreciate it.
Thank you, Manny.
Thanks, David.
Cheers. Bye.
Guys, if you enjoyed watching that, please do like, share, subscribe and comment for regular property updates.